Thank you for joining us for another episode of Baker Hosts Ad Nauseam, a podcast series focusing on new and trending advertising issues with an emphasis on the FTC and the NAD. I'm Connor Corbett, your new host for Ad Nauseam, and you're listening to Baker Hosts. We are once again joined by Amy Mudge and Daniel Kaufman, two partners from Baker Hostetler's advertising, marketing, and digital media team. Together, they have decades of advertising experience and approach advertising issues from multiple perspectives. On today's episode of Ad Nauseam, Amy and Daniel are back with national treasure and all-around great person, Lesley Fair, a legal expert, distinguished law professor, and former senior attorney at the Federal Trade Commission. In their two-part interview with Lesley, Amy and Daniel discuss her experiences at the FTC, memorable cases, and what she thinks of the current legal landscape. With that, welcome to Ad Nauseam, and let's turn it over to Amy, Daniel, and Lesley for part one of You Have Lesley Fair Notice.
Welcome back, dear listeners, to Ad Nauseam. One of the many things Daniel and I love about doing this podcast is it gives us a totally legit reason to reach out to some of the people we admire, we adore, who have so much knowledge and experience, who might be open to sharing that with our beloved audience.
Yes, Amy, and our special guest today does check all of these boxes. Lesley Fair is a former FTCer. She spent many years litigating FTC cases. She created the agency's award-winning business blog, taught consumer protection at law schools in the DMV for many years, and is renowned as one of the nation's true experts on all things consumer protection and the FTC. She won the FTC Lifetime Achievement Award and, most importantly, the recipient of Ad Nauseam's first and only Advertising Law Icon Award. And with that very modest intro, Lesley, welcome to Ad Nauseam.
Thank you very much. I keep my little trophy right by my desk for having the Ad Nauseam Award. And by National Treasure, I assume you mean the very cheesy Nicolas Cage movie. So yeah, I'm like that for sure.
Daniel ordered that on Etsy, all right? He spent several dollars on that, Lesley, but he was very proud of it.
It's lovely. Thank you.
So, Lesley, there is so much we want to talk to you about that we've probably decided up front we're going to turn this into a two-parter. But today we want to focus on your exceptional knowledge and expertise in advertising law. We really thought it would be fun to talk to you about some of the seminal FTC advertising cases that every lawyer should know about. Probably for the next episode, we'd really like to focus more in depth about your career at the FTC and then get into some of that awesome niche stuff about FTC lore and law that people can try to be as cool at ad law cocktail parties as you are, dropping all the B-side stuff and the obscure info.
And all those cool ad law cocktail parties that I don't get invited to.
Hey, they're the only cocktail parties I get invited to, Daniel, okay? So they're cool.
Okay, so before we get to that, though, Lesley, we got a few questions to ask you. We want to get our audience to know a little bit more about the personal side of Lesley, and I'm going to start with first concert you ever saw.
First concert was Rod Stewart, but
Yes.
I left halfway through it because I was really there for the opening act. And it was the magnificent and underrated Jay Giles Band. Who was, yeah, you get it. You get it, Amy. Yeah. So that was the first for me.
Now, if you could go back in time, who's a top performer or performers you would love to have seen?
Well, I would have to say two. Jim Morrison at his height with the Doors and Ella Fitzgerald, preferably not in a double bill.
So my two, and I'm going to jump in even though we're not telling our stuff, Linda Ronstadt, The Carpenters, and Queen for a third.
Those are pretty good.
Yeah.
I have seen two of the three of them.
Oh, that's amazing. Okay, favorite reality show?
Well, since I spent many years emailing you regularly about reality, both of you about reality shows, I like the ones where they're actually doing things like Top Chef, Project Runway. I don't do any of that Rose stuff. I don't do any of the overseas fiance stuff. And I've gotten so desperate that I'm actually watching now. It's an HGTV ripoff, but taking place in a condo in South Africa. So I really do need, to refresh that. So I basically have HGTV on in the house, kind of like Muzak. And so now those are my favorite reality shows.
But wait, your favorite, and Daniel's as well, your beloved connection is Great British Baking Show, right?
I adore the British Baking Show. And I love Extra Slice, which most people in the United States aren't aware of because they have kind of a snark fest show after each episode
Oh, yes,
that we don't get in the
please.
United States, and it's well worth it.
I've been watching, there's a number of TikToks when the show is live where people are trying to recreate the signature, not the signature bakes, oh gosh, I'm forgetting what they call it.
The technical
Technical
challenges
challenges. Thank you.
or the showstoppers.
The
Yeah.
technical challenges. It's sort of fun watching people try to, and you
Yeah.
just see how incredibly difficult it is.
Yeah.
So you are the only guest I would ever ask this question to because I have a feeling you're going to have an answer. Favorite member of the Rat Pack?
Well, for years, I had a big sign in my office at the FTC that said, "It's Sinatra's world. We just live in it." But I'm not going to say Sinatra. I'm going to say
Sammy Davis Jr.
singer, dancer, and dramatic actor extraordinaire, Sammy Davis
I
Jr.
knew it. I knew it. Okay.
What, you think I was going to say Peter Lawford and Joey Bishop? Really? Come on.
I know his All in the Family appearance was legendary. I love that. And finally, your favorite, I know you're a big fan of film noir. Favorite film noir?
Well, I love all of the classic stuff. Postman Always Rings Twice, Double Indemnity. But I'm going to go for a deeper, newer cut. And by newer, I mean only 45 years old. And that is William Hurt and Kathleen Turner, Body Heat. And why I mention that, it must have come out when I was studying for the bar. And you know how they always said, relax the night before the bar, go to a movie. I went to see Body Heat. For any law students who are listening to this, do not see Body Heat because the entire movie, I guess it's not a spoiler alert when the movie came out in 1980. The spoiler alert is the entire movie ultimately revolves around a misinterpretation of the statute of frauds, which Kathleen Turner figured out and I didn't. So I went the next day into the bar exam on Texas wills and estates feeling a real lack of confidence. So I would say Body Heat.
All you bar students out there obviously see this movie, and maybe this was the secret to Lesley Fair's great success, because clearly she nailed it out of the park at the bar and every year thereafter. But there's a lot to digest from that. Daniel, those were awesome questions because I do think you dug into a little bit of the Lesley Fair psyche that we really know and love. But look, we got to do it. We got to get back to the ad stuff. That was the nauseum. This is the ad. And at the outset, we'd love to talk about some cases with you. And we pre-selected 3 that we think practitioners in our area should know about. Some of them we've actually talked about on our show before, but wanted to get your take on them. And thought we'd start with a case that gave us modern unfairness. And that is, of course, International Harvester. Now, we don't necessarily think of unfairness immediately when we think of advertising law, or maybe we didn't used to, but there is a long history of unfairness being used in a range of core advertising areas, including ads directed at kids, and then also on the data security protection side. So let's talk about International Harvester. Daniel, why don't you set it up for us?
Okay, so we've got International Harvester. It is a case involving farm tractors, and it's a decision that is ultimately issued by the commission. Now, we of course don't see many consumer protection cases involving farm equipment, but there was an issue that was raised in this one tractor model's engine, and this was known as fuel geysering. If consumers would remove the fuel cap when the engine was hot, bad things would happen so that the hot fuel would suddenly shoot into the air. So, Leslie, maybe we can start by putting this case into perspective. It's the early 1980s. Broad shoulder pads are in effect, lots of stuff going on. But why is International Harvester significant?
Shoulder pads were later in the 80s, Daniel. I'm sorry.
Oh,
You must be that it was the beginning of all good things. But sorry about that, Leslie. I had to correct a misstatement.
Unfairness was actually a big issue in the 1980 presidential campaign because before International Harvester, the FTC had a 3-part definition that came out in a case dealing with S&H green stamps. And I remember S&H green stamps very vividly. My job at home was to lick those stamps. And then if you get 21 books of stamps, I think you got a heating pad or something like that.
A
It was
plate.
really
A
plate.
plate.
Yeah,
My
not
grandma
much.
collected the plates.
Yes, not much of what you got. But up until then, the standard that the FTC had and that the Supreme Court approved, the real sticking point was the second prong, which was, quote, whether the practice is unethical, immoral, oppressive, or unscrupulous. And I think anybody looking at those definitions can appreciate why people on all parts of the political spectrum had a concern about whether those phrases were a little ambiguous, a lot ambiguous, a little loose. And so, one of the things that happened during, again, the end of the Carter administration, beginning of the Reagan administration, is Congress saying to the FTC, we want a clearer articulation. Because a number of the cases that the FTC had brought under unfairness, I think certainly not a case, but the big project was KidVid. And anytime the Washington Post refers to a federal agency as attempting to be a, quote, national nanny, good things are not going to happen on the Hill and in public opinion. Now, certainly some unfairness cases had been brought without much controversy. I think my favorite, and by favorite I mean least favorite, was a case against a company. I remember back in the day when you got your Sunday morning newspaper, where the funny papers were, you'd get a little plastic insert that would have coupons, but it would also have salad dressing samples, shampoo sachets. Well, this company, a big company, decided, wouldn't it be great to give out free samples of our razor blades right next to the kids' funny papers? And so the commission did use unfairness in that area. So there were some areas where there was agreement, but what is unethical, immoral, oppressive, or unscrupulous? That is a real difficult thing to define. And I think that's why Congress and the new FTC really said it's about time we come up with a clearer definition. They formed the three-part definition that's in existence now. I won't quote it, but that has now been built into, in 1994, into the FTC Act itself.
Well, Leslie, why wouldn't in the International Harvester case, why couldn't the FTC have just used deception? Like, presumably, I'm not a tractor ad connoisseur, but presumably there were claims that the tractors were safe or well functioning. So, wouldn't that be a claim? Why was the unfairness theory necessary there?
Well, there were actually, as I recall, certainly ads that said that this is a great tractor. I don't think there was much specifically on safety.
Okay.
And certainly, had the company made specific safety claims, that makes more sense. And certainly omissions of information under some circumstances can be deceptive. It's usually omissions in light of the representations made. The FTC Act does not require companies to disclose every possible bad thing that can happen. And fuel geysering raised a lot of interesting questions in this area.
Well, how bad was it?
According to the FTC opinion, there were about 90 instances, a dozen of them very serious, and they had been, interestingly, known to the company for about 17 years. And so the FTC looked not just, that's a small number of injuries, but when there were injuries, they were pretty darn catastrophic. And so I think this is, how do you handle a product that does not say we're the safest tractor around, yet is causing injuries that the company knows about? And I think that's one of the reasons why this was important. And it's important to remember, basically what happened is that the farmers were driving the tractors, and most farmers keep tractors for a lot of years, from what I recall, the expert said. And all of a sudden, the tractor would stop working. Most farmers would assume it's run out of fuel. So what's the obvious thing to do? Unscrew the gas cap, which is what caused the fuel geyser.
Okay.
And add to this, back in the day, I don't know the statistics on this, but it was not unusual for farmers to smoke while riding tractors. And so this really led to some catastrophic injuries, a small number of catastrophic injuries, but serious ones.
Fascinating. So, as part of the harvester decision, the commission issues, it's a letter to the Senate and what we now refer to as the policy statement on unfairness. And eventually, as you mentioned, Leslie, it's codified into the statute. So 40 years later, and we're still turning to this statement when we consider unfairness issues. So to what do you attribute this sort of longstanding reliance on that statement? And what are your thoughts on whether the commission struck the right notes?
I think some of it is just how practical and real world the statement is. It raises the problem with words like unscrupulous and unethical. It also points out the fact that what's material to consumers can vary greatly. I mean, one of my favorite quotes from a harvester, it says, "The number of facts that may be material to consumers and on which they may have prior misconceptions is literally infinite. Consumers may wish to know about the life expectancy of clothes, the sodium content of canned beans, or the canner's policy on trade with chili. Since the seller will have no way of knowing in advance which disclosure is important to any particular consumer, he will have to make complete disclosures to all. That just doesn't make sense." And we still hear that. I hear from a lot of my students, I think there ought to be a requirement to disclose a company's labor policies or their environmental policies, or how many women are on their boards of directors. Those are factors that are material and relevant to a lot of consumers, but not to a lot of others. But I think one of the reasons why this has remained so helpful and so useful, it was the product, even though it was a big fight, it was the product of a bipartisan commission. And I have often thought, I still think, that the FTC works best when it works together across aisles. There is not, from my way of thinking, a Republican solution or a Democratic solution. There's a good solution. And I do
Amen.
think that's one of the reasons why it's been so important. I'll mention two things about Harvester that are a little less well known. The point I had mentioned about the company knowing about the problem, I think about 17 years earlier, they had sent out what they called a service bulletin to their dealers that referred to the issue of fuel effervescence. That's a great phrase. I think of effervescence as kind of a refreshing carbonated beverage, not something that's going to burn a farmer to a crisp. And I think this is an important message beyond unfairness to businesses about communications to distributors and consumers. There's a recent data breach case where the FTC alleged that the company's notice underplayed the seriousness of the breach, basically said not to worry, everything's okay, when such was not the case. So it's important to remember, just as a sidelight, that those communications, I think the FTC has and will continue to look at those communications. The other thing I want to mention is fuel geysering is still with us. And I learned this relatively recently. It's in the area of chainsaws, that chainsaws have the same problem, that when it's a vapor lock type issue, you think that the chainsaw is not working because it's out of gas. What do the people do? They open up, and of course, the fuel geysers. The good news is there are not a lot of people using chainsaws and smoking. That's the good news. The bad news is where these fuel geysering cases are now coming up, at least according to the allegations and the dozens of cases that have been raised, are dealing with injuries to forest rangers and firefighters dealing with wildfires, especially at high altitude, because fuel geysering is much more likely to happen at high altitude. And let's face it, even worse than a cigarette butt hanging out of somebody's mouth, or when you are doing this in an area of active wildfires, fuel geysering is still a real problem, at least according to these lawsuits, still causing substantial consumer injury.
Thanks, Leslie. That's such an interesting analysis there. And just to remind our listeners, the unfairness test, the three-part test, does the conduct or practice cause or likely cause substantial injury that's not reasonably avoidable by consumers and that it's not outweighed by benefits to consumers and or competition?
Oldie but a goodie. Oldie but a goodie. All right, next up. We thought we'd stick to one of the biggies. We love this case. We talk about it a lot. And that's Kraft and the Seventh Circuit. And yeah, we love this case at Ad Nauseam. And it's not just because of my obsessive love of cheese and all things cheese food. But in this case, the FTC challenges advertising claims made for sliced cheese. And in the ads, Kraft touted that each cheese slice was made from 5 ounces of milk and gave you all the calcium you needed. But that in doing so, the FTC alleged the company implied that each slice contained the same amount of calcium as 5 ounces of milk. And, we're in the late 80s, the early 90s. Calcium consumption was becoming more of a big deal. But in fact, some of that calcium that went into the cheese slice, I guess, was cooked away. So you got less calcium in a Kraft cheese slice from that 5 ounces of milk than you did drinking 5 ounces of milk. So, Leslie, tell us about this case on the claim side and what you find particularly noteworthy.
Yeah, the part of the claim, I think Kraft is very interesting because the FTC, the case was brought before an ALJ. It then went to the commission and ultimately went to the Seventh Circuit. But I think at all three levels, I think it's helpful to remember that the fact finder looked not just at what Kraft said, but also looked at the visuals. For example, a scene pouring of 5 ounces of milk. I think another interesting point is that most of the ads were targeting parents, that these were ads that showed little kids. The class picture ad, don't shortchange your little shortstop. How could I look into those blue eyes and cheat them out of calcium? I don't know where that 35% of calcium goes. I guess there's a home for undigested calcium somewhere out there. But I think it's an interesting case that the ALJ, the FTC, and the Seventh Circuit really did a deep dive into what was said, when it was said. It has a real interesting footnote about an attempted fix that Kraft tried to make in the middle of the ad campaign that the Seventh Circuit said was not effective. And it also looked at the visuals. And I think that, that glass of 5 ounces of milk was very important. And obviously, ultimately, Seventh Circuit held in the FTC's favor.
So, Leslie, so where do things ultimately land with the Seventh Circuit?
The takeaway, it seems to me, is that the FTC doesn't necessarily need extrinsic evidence, certainly not for express claims, or also for implied claims, when the implied claim is reasonably clear on the face of the ad. The court was happy with the FTC's reliance on its own analysis, saying that was sufficient because the claims were not ambiguous, and said that customer surveys or consumer surveys or copy testing wasn't necessary for self-evident claims. That asks a lot more questions than it answers. But I think what it says, it kind of sets up a sliding scale, if you will, that the more implied the representation, the higher the burden the FTC is going to have to prove that consumers saw the claim and found the claim material. And materiality was a big issue in the case, too. If you just ask consumers, why do you buy Kraft singles? They might say things like, oh, it's more convenient. They don't go bad in the refrigerator. My kids like the taste.
It's
delicious. But if you say, is calcium one of the reasons you do it? What parent is not going to answer that question? Yes. And so there's a lot that Kraft says about methodology that I think is important also.
So our buddy Randy Shaheen isn't here. I know you know Randy also, but he always focuses on there's language in Kraft where the court urged the FTC to help develop uniform standards for surveys. In its words, advertisers and the FTC wouldn't go round and round on this issue. And needless to say, as you and I know, that hasn't happened. But any thoughts on the role that surveys should play or do play for sort of FTC advertising cases?
I think it's important to look at the next case after Kraft, and that was the Stouffer case. The FTC staff, my guess is, I can't speak for them, probably thought those claims were pretty clear too. But in that case, the FTC staff went into court with copy testing. And I think what Randy is right to point that up. I would also say that it's a lot harder to come up with a one-size-fits-all approach. It has not been able to be devised in Lanham Act cases or any other kinds of case. And I think there's also a lot of controversy about the FTC's role in offering guidance like that to businesses. And I think that's an important thing that Kraft said, I think, to FTC staff, yes, this is going to be okay for right now, but don't get ahead of yourself. And you're going to always be safer with empirical data. And I think in the many years since then, I think the FTC staff has gone forward with much more empirical data. But do I agree that it would be nice if there were a way to come up with standards? Yes, I just don't think it's easy.
And probably one of those other things, Leslie, that you said that would be a great thing if we could have it be a non-political, non-partisan. Maybe we should wait for a time, hopefully until we're back there, to maybe revisit this.
That would be nice.
Yeah. For case number 3, we thought we'd include a fun one and not talk about food anymore since you're making me hungry. So this is an issue that is important to many of us as well, hair removal. The case is Removatron, and this is also an FTC administrative decision that gets appealed to a court of appeals, this time to the First Circuit.
Removatron made some pretty strong hair removal claims, in particular claims of permanent hair removal. This is challenged administratively, and the FTC issues a cease and desist order. It's then reviewed by the First Circuit in 1989. I will note the product used tweezers to grasp the hair, but also emitted some sort of radio frequency energy that was supposed to stop the hair from coming back. And sales were made mainly to beauty parlors at a cost of $4,000. And claims were made that the product was clinically proven and an alternative to electrolysis. And the commission ruled that the company needed at least one solid randomized control trial, an RCT, for such claims. So, Lesley, let's talk about the claims first. What does the court find?
Net impression was a key issue there. The company basically said, we didn't claim we removed 100% of hair 100% of the time. And the First Circuit did not accept that as a defense in the case. And it also didn't matter if those weren't the words they used. They looked at a common sense reading of the ads. This came at an interesting time where the FTC had a number of cases that dealt with areas that will always make people money, growing hair where it isn't and removing hair where it is. Nobody's ever lost money going into that line of work. And this was at about the same time a number of the baldness and hair growth cases were coming around. One of the company's other interesting claims they made, they were careful to qualify their claims. And that's one thing, perhaps, if you're dealing with a professional audience, if you're advertising in a dermatology journal or even in a journal for estheticians or something like that. But this was also a product sold to consumers. And the First Circuit said that those qualifications were not sufficient to undo the underlying claim.
I also love the company's argument that when they said it was clinically tested, that didn't mean it was supported by rigorous scientific testing. But then we get into the substantiation. So, Lesley, what does Removatron tell us about substantiation?
That consumers find claims about testing very persuasive. And that if a company is claiming, well, we have done well-controlled clinicals, it is perfectly reasonable for consumers to conclude that the result of the clinicals were that the product worked. So just spending the money on the clinicals is not enough. They have to be methodologically sound, they have to show the results, and they have to be carefully tied to the claims companies make. And I think later substantiation cases sort of show that same thing.
So, do you think this case might have landed differently if they just made the base hair removal claims and not doubled down with these establishment or clinically tested claims?
That's possible, Amy. I also think, in my experience, I don't know what it is. Well, I guess I do know what it is with marketers. It's as if they cannot resist making the establishment claim. And why? I think we know, because they are very persuasive to consumers. I expect Removatron to say, we think we have a great product. They wouldn't be selling it if they didn't think that. But once the ad claim says, don't believe us, believe what these experts say, believe what this clinical research says, that to me is uniquely persuasive to consumers. And it's something that we see, that the FTC sees all the time in cases. And it just seems that advertisers can't stay away from those kinds of claims.
Yeah, so Lesley, if we step back a bit, when I look at older FTC cases, one thing that often strikes me is the deference that courts give to commission decisions and holdings in other cases, and particularly issues such as claim interpretation. And obviously, the courts have changed a lot in the past decade or two. Do you think some of these old FTC cases that we look at might be viewed differently in the 2020s?
I think that's certainly possible. I tell my students all the time, if you took administrative law last year, ask for your money back, because the Supreme Court has entirely changed the picture, not just in the Loper case dealing with Chevron, but even last week, the McLaughlin Chiropractic versus McKesson case. It arose in a different setting. This was a Telephone Consumer Protection Act. It dealt with whether the Hobbs Act requires courts to defer to an agency's interpretation of a statute. Again, not an ad, a statute. There it was the FCC. And the Supreme Court held that the FCC's interpretation of a statute does not mandate deference in the civil enforcement proceeding. Now, of course, that is different from an ad claim. But I think these creeping kinds of inroads into what we thought we knew about administrative expertise, not just at the FTC, all of these agencies, I think this is an area where we could see a lot of differences, a lot of changes coming. There are changes that I personally do not necessarily think are good ones, but I do not wear a black silk robe and a white curly wig. So
Except on Halloween.
I do have that Halloween costume,
No
by the
doubt,
way.
no doubt.
Yeah.
And her blonde hair is flawless every day, all the time. So, Leslie, look, we could talk to you all day long, but there is a natural end to when a podcast episode must close. So, I cannot thank you enough for your time today. We do have one final question, though. Daniel, who is the namer of the podcast and is absolutely brilliant of them, is going to name this You Have Lesley Fair Notice. And he tells me that there is a context for this famous quote. Would you share it with us, please?
There's always a story. Yes. There was a litigated data breach case where the company claimed that it didn't have fair notice of what reasonable data security was. Yet the Court of Appeals opinion cited an FTC business publication that I had worked on and others called Protecting Personal Information, A Guide for Business. And so the attorney in the case said they didn't just have fair notice, they had Lesley Fair Notice. So that's where that came from. He was kidding, of course.
Thank you again, Leslie. We will see you soon for part 2 of this very special Ad Nauseam.
And if you don't show up for the next episode, you have fair notice. You are going to miss some more hijinks and fun. Leslie, we love you.
Thank you both. It's been a delight.
Thank you, Amy, Daniel, and Leslie. If you have any questions for Amy, Daniel, or Leslie, their contact information is in the show notes. For more information on the latest developments in ad law, visit our Adventures in Law blog at www.adventures-in-law.com. And check out all of our Ad Nauseam episodes by subscribing to Baker Hosts wherever you get your podcasts. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.